Good evening, everyone. Bonsoir tout le monde. Thanks a lot for being here tonight for this very special event that we've organized 20 years of fighting for rights in the War on Terror to mark the 20th anniversary of the International Civil Liberties Monitoring Group. My name is Tim McSorley. I'm the National Coordinator of the iclmg, and I'm joining you from Ottawa, Ontario, on the unceded territory of the Algonquin Anishinaabe people. I'd like to acknowledge that the Anishinaabe people are the original guardians of this territory, and we thank them for their stewardship of this land. We recognize their longstanding relationship with this territory and pay respect to all Indigenous people in this region from all nations across Canada who call this land home. We welcome the resistance and resurgence of Indigenous peoples as part of the decolonizing process. We also recognize the importance of remembering this in our work on national security and civil liberties. Indigenous peoples on this land were the first to feel the impacts of Canada's national security apparatus at the start of colonization and continue to be a target of Canada's anti-terrorism laws today. I'm really excited to get this group of excellent speakers who have graciously agreed to join us going tonight. They represent some of the most dedicated, tenacious, and thoughtful activists and advocates and thinkers we've had the pleasure to work with over the past 20 years. Before we move on to them, though, I want to mention a few things about our work at the iclmg. Huck Tassé, our founding coordinator, will talk more about iclmg's origins. But for those who aren't familiar with us, we're a coalition of 45 Canadian organizations from a wide range of sectors, including labor unions, environmental groups, faith-based organizations, legal associations, human rights and civil liberties groups, and humanitarian and international solidarity organizations. We were founded in 2002 and work together to defend civil liberties in Canada from the impact of anti-terrorism laws. We're a member-driven organization, and we hold 2 General Assemblies each year with our members. We're also a member-supported coalition, with a bulk of our funds and support coming from annual contributions from our members. We don't accept government funding in order to make sure that we maintain our independence. If you're part of a group who you think would be interested in joining the iclmg, we'd encourage you to get in touch. Also, a growing proportion of our budget also comes from individual donors, and we wouldn't be able to do our work without the public support either. If you'd like to support our work, you can visit iclmg.ca/donate. And if you'd like to stay up to date on our work, I'd encourage you to sign up for our news digest, which we send every 2 weeks, and is written by Zan Dajne, my colleague, and the iclmg Communications and Research Coordinator. You can sign up for that at iclmg.ca/news-digest. And I think Zan will probably put that in the chat as well too. So our plan for tonight is for each speaker to present for about 5 minutes. Between each, we'll have time for other speakers to jump in and comment as well, as many of them have worked together on the issues that we'll be talking about tonight. And at the end of the presentations, we'll have a Q&A with you and with the panelists. You can type your questions in the chat throughout the night, which Zan will be monitoring, and we'll use them at the end for the discussion. And you can also use the raise hand function during the Q&A at the end. For those of you who are watching on YouTube, you can also point your questions in the chat. Zan will be monitoring that as well, and we'll make sure to get to them during the Q&A. And just so everyone knows, we are recording tonight's panel. We plan on, it will be on YouTube after, since we're live streaming on YouTube, but we're also planning to hopefully put up on Facebook and make the recording available to everyone who registered for tonight. Tandis que les présentations seront en anglais, vous pouvez aussi demander des questions en français. Plusieurs de nos panélistes sont francophones ou parlent français, et si nécessaire, on pourra aussi traduire vos questions vers l'anglais et les réponses vers le français. So with that, I'd like to move on to our first speaker, Huck Tassé. Huck was the national coordinator of the International Civil Liberties Monitoring Group from its inception in 2002 until 2015. Following his studies in political science at the University of Ottawa, he worked as a community organizer and journalist before joining the Ottawa-based NGO Interpares in 1985. For over 15 years, he was responsible for the organization's programs in Central America and Mexico, with a special focus on peace building, refugee and human rights protection, and democratic development. So with that, I'll pass it over to Huck, who I just need to find. There we go.
Thank you, Tim. Good night, everyone. In the aftermath of the 2001 terrorist attack in New York, and under pressure from the US, Canada rushed into the adoption of anti-terrorism laws and other counter-terrorism measures, notably in the area of border control, air transportation, and terrorist listing. That opened the door for the unprecedented deployment of surveillance technologies and data collection on individuals, and enabled practices of social sorting and social profiling, virtually putting an end to privacy protection regimes until then viewed as fundamental principles of free democracies. ICLMG was born out of concerns about the impacts of these laws and measures on civil liberties, human rights, refugee protection, international humanitarian law, racism, political dissent, and even our justice system. The coalition was created 6 months after the adoption of Canada's Anti-Terrorism Act of 2001 to serve as a forum for information sharing, collective action, and for the development and common policy positions to protect the rule of law, civil liberties, and human rights in the context of national security. The central focus of our work at the beginning was to analyze legislation, monitor its application, and document the impacts of the so-called war on terror, with a view to intervene during the parliamentary review of the ATA that was scheduled to take place 5 years after its adoption. To carry out this mandate, we proactively developed collaborations and alliances with international counterparts. Domestically, we reached out to other civil liberties organizations, grassroots organizations, and collaborators in the legal and academic communities. Nurturing relationships and building networks would become a feature of ICLMG's methodology in support of many of its campaigns over the next 20 years. Very early on, we also engaged with policymakers and soon established ourselves as a credible voice on the Hill. This would lead to many appearances before parliamentary committee over the years. But while immersed in this research and policy environment, we were soon confronted with the human face of anti-terrorism, which would drive our agenda for the next 20 years. Indeed, in the fall of 2002, we were introduced to Monia Mazig during a meeting at Amnesty International. Her husband had just been disappeared by the CIA and sent to Syria, where he was being tortured under the US rendition program. The case of Maher Arar would reveal to the world and confirm the existence of this infamous program. Over the next year, ICLMG and its members supported Monia in a relentless campaign for his repatriation against efforts from CSIS and RCMP to block his return to Canada. Then in December 2002, a couple of months after, a security certificate was issued against Mohamed Harkat. His case, along with that of 4 other men, marked the beginning of many ICLMG interventions on the issue of secret trials and deportation to torture. These cases and more individual cases will then be discussed later in the panel. Back to Maher Arar. Following his return to Canada in the fall of 2003, ICLMG mobilized support for a public inquiry into the events leading to his rendition. In January 2004, the Liberal government established a commission of inquiry to look into the actions of Canadian officials in connection with the Arar case. Presided by Justice Dennis O'Connor, the commission was also mandated to make recommendations with respect to oversight and review of the RCMP's national security activities. ICLMG was granted intervener status by the commission, and for the next 2 years, we monitored the entire process, attending almost all of the public hearings. During the proceedings, ICLMG was also invited by Justice O'Connor to participate in a roundtable discussion on oversight and review of national security operations. In our final submission to the commission, our lawyers, Warren Allman and Maître Denis Barrette, proposed a detailed model for oversight and review. In its final report, in September 2006, the Commission exonerated Maher Arar and found that Canadian officials had given the United States false information about him. Justice O'Connor also recommended the creation of an integrated oversight and complaint mechanism for all Canadian intelligence and security agencies. The model recommended differed from the one advocated by CLMG, but it did incorporate many of its elements. During the course of the inquiry, we found out that 3 other Canadian men Abdullah al-Malki, Ahmad Abu al-Mati, and Muhammad Nuruddin had also been detained and tortured in Syria and Egypt with the complicity of Canadian officials. ICLMG and the group of friendly interveners submitted a recommendation to Justice O'Connor for the creation of a second inquiry into these cases, which he did include in his final report. As a result, the government established a Yakabuchi inquiry in 2007 to review the nature of Canadian intelligence sharing with countries including the US, Syria, and Egypt. The commission also sought to determine if Canadian officials were complicit in the alleged abuse. Once again, ICLMG sought and obtained intervener status at the commission. But much of the work of the commission was behind closed doors with few opportunities to intervene. Nevertheless, Justice Yakabuchi concluded that while the Canadian government was not directly responsible for the torture of al-Malki, al-Maiti, and Nuruddin, their mistreatment did arise indirectly from the actions of Canadian officials, likely as a result of erroneous information sharing. Following the two inquiries, ICLMG and Amnesty International played a lead role in lobbying MPs to support the implementation of the O'Connor recommendations, including the model for oversight. In December 2009, all members of parliament, with the exception of conservatives, voted in favor of a motion in support of these recommendations. The motion also called for the government to apologize to Abdullah al-Malki, Ahmad Abu al-Mati, and Muhammad Nuruddin. The O'Connor recommendations were ignored, and the men had to wait until 2017 to receive an apology. But we persevered. In 2014, in collaboration with Amnesty International and the Human Rights Research and Education Center at the University of Ottawa, ICLMG organized a high-profile symposium to mark the 10th anniversary of the Arar Inquiry. The event reunited key actors of the commission, including Justices O'Connor and Yakabuchi, as well as Justice Major, who had presided over the inquiry into the Air India bombing. The three justices discussed the state of national security and human rights and the implementation, or lack thereof, of the recommendations they had made to prevent human rights abuses from happening again. Held in the aftermath of the October 12th shooting on Parliament Hill, the event generated huge media coverage and revived the public attention on the need for oversight. As the Harper government was just getting ready to introduce Bill C-51, the Anti-Terrorism Act of 2014. It would take another 5 years before the Liberal government finally established the National Security and Intelligence Review Agency in June of 2019 as part of Bill C-59. The agency is an overarching review body that can examine all Canadian national security activities, regardless of agencies or departments, pretty much along the lines of the model put forward by Warren Ullman and Denis Barrett 13 years before at the end of the O'Connor Commission. Thus, at last, a chapter was closed on a long journey that started the day that we met Monia Mazig at Amnesty in 2002. Thank you.
Thank you very much, Rock. That was really great. And just so everyone knows, Huck continues to work with ICLMG. He's currently on our steering committee and has definitely continued to guide our work and be involved in these issues. And you know, I don't think it's wrong to say that for the last 2 decades and especially the first 15 years after 2001, Rock was one of the most dedicated and most knowledgeable and leading activists and experts on these issues. And thanks so much for all that you've done, Rock, and for that presentation tonight. Do any of the other speakers want to jump in at this point? And if not, we'll move along to our next speaker. I don't think I see anyone. So next we'll be moving on to Maureen. I just need to find in the video. There we go. Okay. So next we'll hear from Dr. Maureen Webb, who was co-chair of the ICLMG from 2005 to 2010. She is an activist, human rights and constitutional lawyer, and the author of 2 books on technology and society. Illusions of Security, Global Surveillance and Democracy in the Post 9/11 World, published in 2007, and Coding Democracy, How Hackers Are Disrupting Power, Surveillance, and Authoritarianism, published in 2020. Maureen has been invited to speak in many venues, has testified before Commons and Senate committees on national security issues, taught comparative national security law at UBC Law School, and written numerous articles for peer-reviewed legal journals, including one on the extraterritorial application of the Charter, which has been cited internationally, and another on the review of the Canadian Anti-Terrorism Act, which was cited extensively in the trial judgment in R v. Kawaja, striking down parts of the Act. Her law firm, Sasamat Law, specializes in constitutional litigation and research. Thanks so much for joining us, Maureen, and I'll pass it over to you.
Thank you, Tim. Bonsoir, everyone. Very nice to be here with you all. Well, in 2005, ICLMG, I'll carry the story on from Rock. In 2005, ICLMG organized an Ottawa summit of NGOs from around the world to explore concerns about governments' increasingly globalized war on terror measures. And largely due to the kinds of relationship that Roch Tassé and Brian Murphy had built over the years, we were able to get some very big players like EU State Watch, Walden Bello and his group Focus on the Global South, the ACLU, the US Center for Constitutional Rights, and La Ligue des Droits et Libertés from Quebec to come to Ottawa for 4 days and have some deep discussions about what was going on in our respective countries. We saw that governments were bringing in similar measures, working in a coordinated lockstep fashion, and through opaque, unaccountable supranational bodies to bring in measures without democratic debate at the national level. And we felt that the dots in this pattern of this ominous new global governance development really had to be connected, understood, and countered with an international effort by an international coalition of civil society groups. And I think that the work that was done that week was pivotal, because coming together from our respective countries, I think we were able to see quite early on that the war on terror was really an anti-democratic coordinated power grab that was laying the ground for the erosion of national sovereignty and nationally guaranteed constitutional rights for decades to come. You could say that the global surveillance industrial complex developed their playbook and their infrastructure during the years of the war on terror and successfully convinced populations to turn these on the other. And the other at that time were Muslims and political opponents in many countries. And that over the past 3 years, this same surveillance industrial complex has been experimenting in turning a similar playbook and infrastructure on the rest of us, with well along the way plans for making digital ID and digital currency the foundation of a new economy, and chilling success in getting people to acquiesce to what really amount to social credit systems. During that 2005 summit, during that 4 days, we conceived and agreed to collaborate on an international campaign against mass surveillance. And of course, acronyms abound in this work. As you know, it was called ICAMS, for which Ben Hayes and I wrote the core analysis. It was co-sponsored by the groups that I mentioned earlier and launched simultaneously in San Francisco, Ottawa, and London, England, in April 2005. And it was then presented to the World Social Forum that year in Porto Alegre, and nearly 300 civil society organizations signed on to the campaign's manifesto. The people who were involved in the summit and the campaign became close colleagues, collaborators, and trusted advisors to ICLMG for years to come. And many of them were back in Ottawa a few years later for a colloquium of international experts organized by the ICLMG and the University of Ottawa Faculty of Law to draft the Ottawa Principles, a codification of the main areas of international law relevant to government counterterrorism measures. The lessons I think that we learned from that initiative, that early summit that I think was really the brainchild of Roch Tassé, the lessons we learned, I think, was that there's really no substitute for in-person working relationships. Bringing each of those groups in Ottawa was an investment that paid off for years to come. Between 2005 and 2007, I wrote a book based on the analysis of the ICAM's campaign, Illusions of Security, Global Surveillance and Democracy in the Post 9/11 World, to further raise public awareness. And I think we achieved quite a big reach with that. I spoke on Democracy Now!, The National with Peter Mansbridge, BBC World Service, Chicago Public Radio, Air America, anywhere from the Winnipeg Free Press to Playboy magazine. The venues in the United States were big ones like the Chicago Council on Global Affairs, the World Affairs Council of California, the Canadian Association for Security Intelligence Studies, where CSIS, FBI, CIA, MI5 were attending, and many others. And in fact, in Chicago, I met a diplomat who worked closely with the head of CSIS at the time, Jim Judd, and asked me to sign a book that he could give to Judd. And I signed it, Be Good. And he was chuffed with that. So I think that many of the trends that we predicted in the ICAM's campaign and later in the book were really vindicated and confirmed with the Snowden leaks that came later. And something that you really, all of the people working in this area need to be aware of is that the technology of surveillance has made quantum leaps since Snowden. Making these digital ID systems we've been seeing during the pandemic and in recent global governance plans, really, I think, the civil liberties fight of the century. We went on, I'll just say one more sentence, we went on in 2006 to organize the Civil Society Forum that ran parallel to the International Conference of Privacy Commissioners in Montreal. That was largely organized by Roch and Patricia Poirier, I believe. And the forum's recommendations picked up on the content of the ICAM's campaign. And in 2009, the ICAM's manifesto was largely adopted and reformulated at the Privacy Commissioners Conference in Madrid by the Civil Society proceeding as the Madrid Declaration of Global Privacy Standards for a Global World. Thanks, Tim.
Thanks so much, Maureen. Thanks for joining us tonight, and it's great to have you with us. And if people have a chance to pick up a copy of Illusions of Security, actually, there's a question, Maureen, about whether or not your books are available online or where people might be able to find them. Just quickly, is it just for purchase through bookstores or?
You'll find them in bookstores, on Amazon. MIT Press is published my latest book, and City Lights. I think you can still find the book on the City Lights website and store.
Excellent. Great. Thanks so much. And we'll open it up to, I don't know if any of our other speakers have anything they'd like to add or on this part in regards to surveillance. Or there's a couple things I want to just again thank Maureen for the incredible work and for the groundwork that she and others laid with ICAMs for international coordination around issues of mass surveillance. Recently, we've been taking on issues of algorithmic surveillance and facial recognition technology, both here in Canada and working with international partners. And some of those relationships continue to really play out. So for example, we launched an open letter with about 30 different organizations, so not as many as ICAMs, but 30 organizations calling on the domestically and internationally calling on the Canadian government to ban the use of facial recognition technology by federal law enforcement and intelligence agencies for surveillance purposes. And we continue to work with our counterparts in Europe and the United States on coordinating our efforts, because we see how our governments are coordinating their efforts to bring in these new forms of surveillance. I also just wanted to give a mention to a project that we had worked on with some of the other people on the call tonight and who are joining us tonight, the Big Data Surveillance Project, which was another group effort from about a dozen Canadian organizations and experts on surveillance in Canada that was based out of the Surveillance Studies Center at Queen's University. And that also did put out a book called Big Data Surveillance. The exact title is Big Data Surveillance and Security Intelligence. I'm just looking at my bookshelf. If people are looking for that, and you can find more about that project on the Surveillance Studies Center website at Queen's University. And then the last thing I just wanted to mention about our work on surveillance more recently is there's been a lot of discussion around the impact of surveillance for COVID-19 health measures and its interaction with national security surveillance. And so that was one of our main concerns at the beginning of the pandemic. We're not a public health organization, but we've seen how other emergencies have led to vast new powers of surveillance and data collection for national security agencies. And we were able to successfully work with a coalition of other Canadian organizations and with our members to secure a commitment from the federal government that CSIS and the Canadian security establishment, or the communication security establishment, as far as we know, weren't involved and were limited and were blocked off from being able to access any information collected around COVID-19 and weren't involved in COVID-19 public health responses. So I just wanted to add that little bit of an update on some of our more recent work. And then with that, I'd like to move on to invite Dominique Péchard onto the screen. I think Zan will add Dominique.
Sorry to interrupt for a second.
Oh, go ahead. Yeah.
I know Maureen will have to leave soon, and there's just a couple quick questions in the chat addressed to her around currency, and the other one is about social credit system. Like, just give it a little bit more information about that, if you don't mind, Maureen.
Yeah. I would recommend you read a report that came out of the New York University Law School called Paving a Digital Road to Hell. And it describes very well how for the past decade there have been in play plans to institute digital ID systems, which really go way beyond the kinds of things that we've been fighting and staving off relatively successfully in the past 20 years out of the war on terror, and also plans to create digital bank currency. And so we saw, I think in Canada, we saw the how this can be very pernicious. When the people related to the protest in Ottawa with the truckers there were over 200 bank accounts that were summarily cut off by the banks. And if you combine digital ID, which would be which they conceive of as an ID that will be biometric, and this is something that was a new innovation with the war on terror, but will also work across all platforms. So all government platforms, all banking platforms, and most commercial platforms too. So if anybody who works in privacy can see what a monstrosity this would be. And you connect it, then you turn all banking into digital, so that there's no currency, there's no cash, there's no money that you control, that the government and authorities don't have the power to turn off remotely. We can see that it's very easy to construct a totalitarian kind of social credit system very quickly. And I think people had the idea of social credit normalized. And again, it was through this idea of, safety is the greatest good in society, regardless of any other goods, where we had these vaccine passports, where people were actually kept out of the public, out of society and cultural activities, contrary to the UN Declaration on Human Rights, based on vaccine pass status, which subsequently we learned quite quickly that the vaccines didn't stop transmission. And so that undercut the whole regime, and yet the regime went on. And I think it really normalized this idea. And this was essentially a social credit system. So you attach that to a digital ID that works across platforms, is accessible to governments and big business, and then connected to a digital currency. And I think that the New York School of Law and the special rapporteur on it was one of the UN special rapporteurs that helped write that report, are right when they say that we're paving a road to a digital hell, and most people are unaware of what the consequences would be. But I would hope that people who worked since the early 2000s on these issues in the trenches for the war on terror would recognize the dangers of these things immediately, because that's exactly what we've been working against for 20 years. But with incredibly more powerful technology. So I'll stop there.
Great. Thanks so much, Maureen, and thanks for being here tonight. And hopefully we might make, maybe we'll be able to get to some more questions before you have to leave us. Great. So next we'll invite Dominique Péchard. There we go. So Dominique has been one of the co-chairs of ICLMG since 2012. He was also president of La Ligue des Droits et Libertés from 2007 to 2015. And he is currently a member of the committee Population Surveillance, Artificial Intelligence, and Human Rights of La Ligue des Droits et Libertés. Following the 9/11 attacks, Dominique was actively involved in the fight against anti-terrorism measures. He has represented La Ligue at parliamentary committee hearings on national security and surveillance bills. He has appeared regularly in the media and has also given numerous conferences in Quebec on issues related to the proliferation of draconian human rights violating governmental measures. Thanks for being here, Dominique, and I'll pass it over to you.
Alors, bonsoir tout le monde. Good evening, everyone. Well, I've been assigned the formidable task of presenting 20 years of ICLMG work on anti-terrorism legislation in a few minutes. It's impossible in such a short time to even simply enumerate all the interventions on a multitude of legislative pieces, so I will focus on some key interventions that illustrate the principles that have guided the work of the ICLMG throughout the years. The first major intervention, which set the tone for all subsequent ICLMG positions, was the report entitled In the Shadow of the Law, submitted by the ICLMG in March 2003 in response to Justice Canada's first annual report on the application of Anti-Terrorism Act, best known as Bill C-36. The report underlined a series of major concerns with the war on terror initiated after 9/11. The first was the introduction of the new crime of terrorism in the criminal code. The ICLMG rightly pointed out that the terrorist acts were already crimes and that a broad and imprecise definition of what constituted terrorism, facilitating terrorism, and financing terrorism could target a series of activities of political dissent having nothing to do with terrorism. Second, the use of national security argument to deprive people of their freedoms and of the right to know the so-called evidence held against them. Other panelists tonight will provide several examples of this denial of the right to due process and a fair trial. Third, the association of terrorism with Islam and the ensuing racial profiling of an entire community. Fourth, the surveillance powers granted to police and security agencies and the constitution of vast data banks with no possibility to correct errors. Fifth, the information sharing agreements with the US with no control over what the information would be used for. And lastly, the lack of control and accountability over the use of these new extraordinary powers. The report concluded by emphasizing that security is not achieved by limiting freedoms. On the contrary, freedoms are what guarantees our security. Later, during the 2006 parliamentary review of the Anti-Terrorism Act, the ICLMG played a crucial role in the final position adopted by the NDP and the Bloc Québécois, and was instrumental in the drafting of a minority report tabled in Parliament jointly by these two opposition parties. The minority report called for the repeal of the Anti-Terrorism Act. A protracted struggle then took place between 2006 and 2011 when a minority conservative government tried to reintroduce the two clauses in investigative hearings and preventive detention, which had expired on account of a sunset clause in the ATA. The campaign and lobbying of the opposition parties on the part of the ICLMG and others against the reintroduction of these clauses was successful until the Conservatives won a majority in 2011. The Conservative government took pretext of the murder of two Canadian servicemen by two isolated individuals in the fall of 2014 to adopt C-51, the most important piece of anti-terrorist legislation since the ATA. Among other things, C-51 enacted a broad information sharing agreement between government departments, increased the time a person could be detained before appearing before a judge, and gave CSIS the power to commit covert illegal acts. The ICLMG played a very active role in a broad coalition of organizations opposed to C-51, which succeeded in raising awareness and mobilizing a significant part of the population against C-51. With the Liberals back in power in 2015, the ICLMG, along with several other organizations, undertook a campaign for the repeal of C-51, but the government ignored the numerous voices asking for the repeal and chose instead to present and adopt yet another anti-terrorism piece of legislation, C-59. Not only did C-59 not fix most of the problems posed by C-51, it raised more concerns, for example, by granting CST the power to carry out offensive cyber activities abroad. Nevertheless, C-59 was a partial victory, as mentioned by Rock. The ICLMG has campaigned relentlessly since 2006 for the implementation of an oversight mechanism over national security bodies, as proposed by Judge O'Connor in his second report. The government finally responded to this demand by creating the National Security and Intelligence Review Agency. Over the years, the ICLMG has systematically intervened before parliamentary committees to challenge legislative attacks on rights and freedoms, and more broadly, to inform MPs of the dangers of the measures they were asked to adopt. The ICLMG has also worked actively, on its own and in coalitions, to keep the public informed on these issues. As a result, the public today is more critical and wary of surveillance or security measures which infringe on civil liberties and human rights. Thank you.
Great. Thank you very much, Dominic, for sharing all that and for doing a great job of summarizing so many years of legislation into so few minutes. We do have a lot more of a rundown of the different pieces of legislation that we've also addressed on our website at iclmg.ca if people want to find out more, and sure we'll be able to discuss more in the question period later on if people have more questions about either these pieces of legislation or other pieces that we've been fighting to address and improve over the past 20 years. Is there anything that any of our other speakers would like to add just in the next couple of minutes, or if not, we'll move on to our next speaker. Okay, so next up we'll be hearing from Yaver Hamid. Yaver is a human rights lawyer at Hamid Law in Ottawa. Yaver worked for 3 years at a labor law firm focusing on trade union law, employment law, and human rights. For the past 12 years, he's worked on important cases to help individuals and communities to resist injustice, such as discrimination on the basis of poverty, police brutality, persecution of people on the basis of dissident political views, whistleblowing, racial profiling, deportation of migrants, Islamophobia, homophobia, and abuse of prisoner rights. Since 2009, he has also taught a seminar course at Carleton University's Department of Law and Legal Studies entitled State, Security, and Dissent, in which he continues to explore the contemporary and historical human rights problems in Canada with a focus on the importance of material and ideological persecution of dissent by the state. Thanks for joining us, Yaver, and I'll pass it over to you.
Thank you so much, Tim. It's an honor and a privilege to be part of this event with the ICLMG. The ICLMG that does critical work in the areas that national security law and national security practice doesn't really allow us to go. And so my topic that I want to address this evening is on the impact of national security measures on humanitarian charitable organizations. So the context here is that since August 2021, about $80 million in aid from Canadian organizations, we're talking about organizations like the Canadian Red Cross, Doctors Without Borders, World Vision, is basically being suspended. Why? Because with the regime change in 2021 in Afghanistan to the Taliban, there is, a political advice or notice that's coming from Foreign Affairs to these organizations that by doing their humanitarian work, they run the risk of essentially providing material support to terrorism. Now, this is an issue that is nothing new. The ICLMG a few years ago did a report on the issue of Muslim charities being targeted. That focused on the Canada Revenue Agency and how the review and analysis director or division rather was disproportionately targeting Muslim charities in their work abroad. And so in a sense, we are seeing the specter of terrorism now from the other end. That is to say, looking at listed terrorist entities and the potential from interaction abroad coming back on Canadian organizations. So these Canadian organizations may be targeted on the criminal spectrum of things. Why do I, reference the good work of ICLMG talking about the Canada Revenue Agency? It's another sort of piece of the puzzle that I learned, and many of you might have heard about, with a now notorious case, that of Irfan Canada. So you may recall back in 2014, Irfan Canada was the first Muslim charitable organization to be listed as a terrorist entity. That happened in the midst of a process trying to overturn the revocation of its charitable status. And so what we see here in the sort of this new climate is we see the specter of terrorism in international relations affecting the good work of humanitarian organizations, because despite the work that these organizations, as I mentioned before, have been doing and want to do in Afghanistan, for example, they run awry of the fact that they will inevitably be dealing with a Taliban regime. And so the logic, the anti-terrorism logic of that is that, by simply working and paying taxes to in an area where that would be funneled through this terrorist entity, that the work itself is tainted. And so I have a few different thoughts on this. Is that we have to be very vigilant. We have to be mindful of the overreach in terms of how anti-terrorism law is being used on the international stage. I think one of the dangers, and we certainly encountered this in the Irfan Canada case that I was involved with, is that once you have a listed terrorist entity, interaction or any interface with this organization becomes a basis for completely freezing the work that good organization may be doing. And so that's really quite problematic, because these really robust tools of anti-terrorism completely immobilize all the work, regardless of whether this is doing solid work as Irfan Canada was doing in Gaza, in Palestine. The possibility in that circumstance that there wasn't sufficient oversight of the charitable work of Irfan Canada, invoke this problem of terrorist listing. And so what do we need to do in response to this? I think we need to be mindful of the deleterious effect of terrorist listing, generally speaking. We need to also be aware of the fact that the interpretation, I would argue, under Section 83 of the Criminal Code does not encompass humanitarian activity. That is a misapplication to say that humanitarian work, carte blanche, to taint that work and say that it is prohibited work. That is an overreach. We need to be thinking about appropriate legislative amendments that can protect organizations that may be at risk of being, subject to prohibition or taint. And at the same time, I think we must not lose sight of the good work that ICLMG has done with respect to what has been happening with CRA audit. So I think it's a multifaceted problem. We're dealing with the international sphere. We're dealing with the domestic problems under the Canada Revenue Agency. And I think, through a lot of the work that the ICLMG has been doing, finding out about procedural violations, and I think pushing back against what I would argue unlawful overreach of terrorist legislation, shining light on that is something we need to do if we can count on the good work of these organizations moving forward. And certainly a lot of lessons I can talk more about in terms of what we learned from Irfan Canada's case.
Thanks so much, Yaver. That was really great, and thanks for again packing in so much into just 5 minutes. And thanks for all the support that you've given us and all the advice and work that you've done with us over the years. It's very appreciated, and for all the great work that you do and that you continue to do on these issues. And just to add in regards to the issue of the CRA and Muslim charities, one of the things that we found was that this review and analysis division that looks at specifically at countering terrorist financing has almost exclusively looked at Muslim charities in Canada. And that if you look at all the charities that they've looked at, they're all based in racialized communities. The others are either based in the Tamil community or Sikh communities in Canada. So essentially there's this a fairly secretive part of the CRA that doesn't like to be discussed publicly and doesn't really talk about themselves publicly, but their whole raison d'etre is to investigate links to terrorism, but in their eyes and in their work, that's exclusively for charities that are based in the Muslim community and other communities. And it's worth noting that not a single one of those charities has ever been found guilty or charged with terrorist financing. The biggest impact has of course been the listing of Irfan, but most of these other charities, in the final finding against them, it's generally been if there is a problem, it's administrative issues that then result in outsized repercussions and penalties that are much larger than what other charities have faced for similar findings of issues of administrative control, for example. So we're continuing to work on that. The Office of the Taxpayer Ombudsperson right now is conducting a review of the issue. We're still monitoring how that review is going and whether or not it will be effective in really showing the issues. but that hopefully will help to push the issue along and reveal a bit more of where this is coming from and how we can fight to end it. And the last thing I'll say is that we are also working with a coalition of groups, as Yavor mentioned, to develop model legislation, hopefully to protect the work of Canadian organizations working internationally from being pursued for terrorism grounds simply for providing humanitarian aid or assistance. Thanks again, Yavor, and I guess I'll open it up. I don't know if anyone has anything they'd like to add right now, and if not, I'll introduce our next speaker. Okay, seeing that, I'm very happy to welcome our next speaker tonight, Monia Mazik. Monia is an academic, award-winning author, and human rights activist. Her latest novel, Frida, won the Ottawa Book Award for French fiction. Monia is an adjunct and research professor at Carleton University in the Department of English and Literature. Her new memoir, My Personal Journey with a Scarf, an essay memoir about gendered Islamophobia, will be published in 2023. Monia is a columnist with Rabble.ca, ONFR+, Islamic Horizons, and has published several articles in the Ottawa Citizen, the Globe and Mail, and the Toronto Star, among other newspapers. Monia currently sits on the boards of several organizations, including the Rideau Institute, the Ottawa Muslim Women's Organization, the Canadian Centre for Policy Alternatives, and the Association des auteurs et auteurs de l'Ontario français. She is also a member of the International Advisory Council for the Institute for Canadian Citizenship, and sits also on the advisory board of Justice for All. Thank you so much for joining us, Monia. It's great to see you again, and I'll pass it over to you.
Thank you, Tim. It looks like a family reunion this evening, so I'm so happy to see many friends that I didn't see for a long time, but others that I keep seeing more frequently. I have been asked to speak about Islamophobia and the war on terror. So I have written some notes, so I'm going to stick to them. But again, I think as some of my friends already mentioned, there are too many things to be said. So I hope that I will try within those 5 minutes to focus on Islamophobia and the war on terror during those two decades. Immediately after 9/11, as it was mentioned by my friend Rock and Dominique, December 2001, Canada passed its first anti-terrorism legislation, despite the fact that Canada was not affected by any terrorist attacks at that time. Some of you would remember that this legislation was adopted as quickly as one of the quickest legislation in the history of the Canadian Parliament. From the outside, the legislation was written to tackle and prevent terrorism. In reality, that legislation mainly targeted Muslim individuals and groups, but also other groups that were considered or assessed as posing a threat by Canadian intelligence agencies to the political, social, economic interests of Canada. Financial and human resources were diverted and amplified overnight, almost, to spy on Muslims in their working place, in their place of worship, on university campuses. Muslims came to represent the other, those who Canadians should fear, suspect as violent or prone to violence because of their religious beliefs. This conclusion was not reached through any empirical or scientific studies. It was decided so because the perpetrators of the 9/11 attacks in the United States were Muslims, a sort of a big generalized guilt by association inference. In 2002, 3 Canadian Muslim men, Meher Arar, Abdullah al-Malki, Ahmed al-Maati, were arrested in Syria and Egypt. They were either rendered or arrested upon their arrival to these countries and later they were detained, tortured in prisons under the request and the complicity of the Canadian government. Of course, as Rock mentioned, that was determined later on, years after, with both of the inquiry, the O'Connor and the Akabuchi. 4 years later, another man, Moayed Noureddin, will share the same tragic fate. He was detained, tortured, and imprisoned under the request of Canada. It took almost a decade until the Canadian government acknowledged its wrongdoing. However, this did not stop Canada from enabling the anti-terrorism legislation, nor continuing arresting Muslims and convicting them under the anti-terrorism legislation. So far, with the exception of the person who killed 4 Muslim members of the same family in London, Ontario in 2021, only Muslim individuals have been charged and convicted under the Anti-Terrorism Act, for which the thresholds of guilt are lower than for any other criminal acts. In the last decades, several Muslim Canadians were detained abroad by oppressive regimes who justified their action through their own terrorism legislation, or the so-called global war on terror, to arrest, imprison, and silence political opponents or individuals with beliefs and ideas that oppose these regimes. Canada kept its head under the sand and barely lifted a finger to help these Canadians until public campaigns, among others, iclmg were involved with many of them, were devoted to these individuals by their families, friends, and human rights activists to release them. This was the case, for example, of the Canadian citizen Abu Sufyan Abdulrazik, who spent about 6 years in Sudan, struck in the Canadian embassy in Khartoum. Upon his return, he declared publicly that CSIS told him that Sudan will be your Guantanamo. The Canadian government refused to deliver a Canadian passport to him while he was in the embassy. Then they put many obstacles for his return, including him on the no-fly list and threatening anyone who would pay for his plane ticket to charge them with association to terrorism, until a group of brave Canadian citizens paid for Abdulrazik's plane ticket and defied Canada to charge them with terrorism, which they did not. The example of Ben Ammar Benata, a refugee from Algeria who arrived in 2001 to Canada from the US after his visa expired there. He claimed the refugee status in Canada, but because of his work as a pilot in the Algerian military, and because of his religion, and because of his refugee status, he was racially and religiously profiled, and instead he was turned over by Canadian authorities to American officials who detained him and kept him imprisoned for 5 years, even after being cleared from any terrorism suspicions. Following the Arab Spring in 2011, Khalid Al-Qazaz, a Muslim permanent resident who studied in Toronto, traveled to Egypt to work in the office of the newly elected Egyptian president at that time. He was arrested and detained there. His Canadian wife and their 4 children were barred from traveling back to Canada. Their assets were frozen by the Egyptian authorities, and Canada once again did almost nothing to press the Egyptian authorities for his safe return. The Canadian businessman, Salim Al-Aradi, another case that iclmg was involved with, was kidnapped, tortured, arbitrarily detained by the United Arab Emirates in 2014 because of his trade ties with Libya and the influence on political interference of the UAE in that country. More recently, Yasser Al-Baz, another Canadian businessman, was arrested in Egypt in 2019 and imprisoned without charges until a campaign by his family and friends and human rights activists helped to release him and bring him home. I have a question here. So if these men were not Muslim, were they being arrested, imprisoned, and tortured If these men were not Muslim, would Canada be shy and silent in defending their rights, and worse, being complicit in the abuse of their rights? Just remember the public outcry by Canada at the arrest in 2018 of the two Michaels in China. Meanwhile, in Canada in 2006, Muslim men were arrested and charged for planning to detonate truck bombs and attack the Canadian Parliament in Ottawa, the CBC headquarters and CSIS offices. They were called the Toronto 18. They were a group of 18 Muslim Canadian men who were arrested and charged under the Anti-Terrorism Act. 7 pleaded guilty, 3 adults and 1 youth were convicted and served few years, then released. 4 adults and 2 youth were released after the charge against them were stayed, and 1 youth had his charge dismissed. Despite the public knowledge of the group, that the group was infiltrated and incited to commit those planned attack by an agent working and paid by CSIS as a CSIS informant, these individuals were portrayed in the media as homegrown terrorists and harshly convicted accordingly. Another category of Canadian Muslims that were arrested and charged during the last 2 decades were the lone wolves, those who presumably acted on their own and introduced in the public vocabulary as representing another threat. So if added to the first category of the sleeping agents, mainly refugees or permanent residents, then to the second category of first-generation Muslims kept in foreign prisons, we will have a panoply of categories depending on their age, their background, their time of arrival to Canada, attacked and arrested under the Anti-Terrorism Act. The latest category I would call the radicalized, and those who were born and raised in Canada but disenchanted with Western lifestyle and attracted on the internet by some propaganda that encouraged them to join ISIS. The second version of the anti-terrorism legislation mentioned by my friend Dominique Péchard was adopted in 2015 and was cut specifically for this other category of people arrested. And despite Canada having many other Canadian citizens who go abroad, join military conflict, like very recently in Ukraine, Muslim Canadian who joined any military zone or found themselves trapped in any of those dangerous zones were automatically labeled terrorists, and this prevented from returning to Canada and have the same right as any other Canadian. This is in a very, very brief time, and I'm glad that I mentioned some of the most important categories. This is what Islamophobia looked like in Canada within those 20 past years. It is our resistance, denunciation of these unjust practices and discriminatory laws that should bring us together so we can build an Islamophobia-free society that would respect human rights. Thank you.
Thank you so much, Monia. And I know, yeah, it's a lot to ask to cover in just a few minutes, but you did an excellent job as always. And thank you again for everything you do and for your commitment and passion. And it's always a pleasure to work with you. And I don't know if everyone knows, Monia is also currently one of the commissioners for the Ottawa People's Commission. We have the pleasure of working together on that as well. That's looking into the impact of the last February's convoy occupation on the residents of Ottawa and Gatineau. And yeah, so thank you very much, Monia. I'm looking forward to the discussion later on and the questions that we'll have from the audience. Next, we'll move on to our next speaker. So I'd like to invite up, just make sure I'm right. Yes, Matthew Behrens will be speaking next. Matthew is a freelance writer and social justice advocate who coordinates the Homes Not Bombs Nonviolent Direct Action Network, the Stop Canadian Involvement in Torture campaign, and the Campaign to Stop Secret Trials in Canada, among many, many others. He has written extensively for Toronto's Now magazine and Rabble, examining the connections between national security and civil liberties. He has worked closely with victims of the Canadian and US national security, so-called national security apparatus for many years, including with Abdullah al-Malki, Ahmed al-Matsi, and Muya Nuruddin, who were rendered to torture, and Mohammed Harkat, who is still the victim of a security certificate and secret trials. He is also currently campaigning for the return of Canadians detained in Canada's Guantanamo in northeast Syria and helping many refugees navigate Canada's Kafkaesque immigration system. Thanks for joining us, Matthew, and I'll pass it over to you.
Thank you. It's great to be here with so many wonderful people, and I think for me, you know, we talk about these issues and they sometimes seem so overwhelming, but I think if I think about the ICLMG, I think about the commitment of a relatively small group of people relative to the Canadian population who have made a huge difference in turning back the forces of repression of the state. And we've learned a lot of lessons along the way. And I think one of the lessons that's really, really critical is that we have more power than we know. And that really scares the hell out of our opponents in CSIS and the RCMP and the Injustice Department. And I wanted to use part of my 5 minutes to quote one of the most reprehensible human beings on the planet, Samuel Huntington. Some of you know that name from a book he wrote called The Clash of Civilizations, but he was also the author of a book that was produced by the Trilateral Commission coming out of the 1960s and 70s called The Crisis of Democracy. And when I look at this, I take great hope because the Trilateral Commission and this book came as response to the fear of the social movements of the 1960s and 70s, the civil rights movement, the women's movement, the ecology movement, the lesbian gay liberation movement, the ecology movement. And what they concluded in this book is what they called the dysfunctions of democracy come not primarily from external threats, though such threats are real, nor from internal subversion from the left or right, although both possibilities could exist, but rather from the internal dynamics of democracy itself in a highly educated, mobilized, and participatory society. There are potentially desirable limits to the indefinite extension of political democracy. The problems we are seeing of governance in the United States today, in other words, we're losing control of the system because there's so many people protesting in the streets, quote, stem from an excess of democracy. What we need instead is a greater degree of moderation in democracy and a reminder of the legitimacy of hierarchy, coercion, discipline, secrecy, and deception, all of which are in some measure inescapable attributes of the process of government. Now, the Trilateral Commission, of course, was a creation of the 1970s, and there were many Pierre Trudeau cabinet ministers who were part of this organization as well. And I say that just to remind us that these guys really are on a fragile precipice when it comes to democracy, and they try and keep us afraid. And the thing that they are most scared of is when there are these outbreaks of democracy. And so the CSISs and the OPPs and they're not really worried about terrorist threats because they don't really exist in the way that they imagine them. Because they are largely creations, as Monia pointed out, of Islamophobia. And that's why they didn't see that a convoy of white supremacists coming to town to overthrow the government, they were in a problem because they couldn't find a link to indigenous land defenders in them. They couldn't find a link to Muslims or pacifists to actually determine if they were a threat. And as we saw this week at the commission over the last 2 days, these agencies were actually working with and sharing advance information with the white supremacists who were trying to overthrow the Canadian government. So I think the fact that they constantly push for secrecy and more powers, that's a testament to how scared they are of small groups of us who actually, we call their bluff, we question their racism and their threat exaggerations and their incompetence. And it's a reminder of something that Tom Hayden, among others, talked about. It's called the long 60s, which is that spirit of democracy that so threatened the Trilateral Commission. And 50 years later, they're still trying to beat that back. The two things I wanted to focus on tonight are security certificates, the Secret Trial 5, and the returnees from torture that Monia had mentioned and others have mentioned. And the first thing with security certificates is a real simple statement. They're not used anymore. They're not used anymore. Why has the Canadian government been forced to not use one of the most draconian, powerful tools of repression in its arsenal? Because as a group and as a community, a small community, but a powerful one, we made it politically impossible for them to do that. We did such a good job that they literally stopped being issued just after the Sharkawi decision in 2006. And that was a landmark moment because at that point, you had the Supreme Court take this group of stigmatized and demonized, racialized, securitized human beings, and they'd finally had some of their humanity recognized. Yes, they have charter rights, despite this terrorist label that has been misapplied to them. How did that happen? Well, it happened because of the dedication of groups like ICLMG and the Campaign to Stop Secret Trials and the individual support campaigns, but it also happened because of organizing and principle. People refused to kind of cut a deal and say, well, they are terrorists, but we actually did something called the presumption of innocence. And that's a very dangerous thing to do. But nonetheless, I think that's what really worked. And also what happened is that the families seeing these campaigns and the men themselves felt okay to start speaking up. And when they started to speak up, people saw them as human beings. They saw them as parents. They saw them as spouses. They saw them as loved ones, people who love and are loved. And that made a big difference as well, because there you had CISA saying this person is a big Al-Qaeda, wheel. And then you look at them and you just go, I wouldn't rely on one of these guys to bring a bullhorn to the demonstration. But ultimately, I think what this campaign showed us is that we can restrain state power. CSIS was so upset about the public campaign around the secret trials that the former head of CSIS, Jim Judd, actually lamented in 2009 that we had turned these men into folk heroes and we were making it difficult for them to be stigmatized. But much as that's a successful part of our campaign, we also learn, as always, that the state kind of does a bit of a strategic retreat, and then the Hydra grows another head and another tentacle. So now what we're seeing is security certificates without detention, inadmissibility hearings against people based on unnamed, unspecified, secret state security allegations are now being used in the refugee determination process and inadmissibility hearings, not by the 5s and 10s, but by the hundreds. And so we still have a lot of work to do because there are people who come here from Colombia, from Palestine, from Ethiopia, and other countries, the Philippines, who are deemed security threats. They're not told why, but because they're not detained, they're not on our radar. And we see this trend to secrecy. Sorry, Tim, I'll try and wrap up with Abu Sufyan Abdul Razik, who has a lawsuit against the Canadian government. In 2018, that lawsuit was pretty much shut down for 4 years because they've been in secret under Section 38 of the Criminal Code to try and put in secret evidence against him. And we've also seen that in the manner in which the Federal Court of Canada has not only received the application, but they've granted a secret hearing in the case of the 44 Canadian Muslims who are detained in Syria. I just want to wrap up by reminding you of how dangerous we are as a group of people who believe in democratic rights. In 2008, we hit the road with Abdul al-Malki, Ahmed al-Mahdi, and Mulyad Nuruddin with anti-torture caravans to educate people and to try and open up the very first secret hearing that had been called under the Public Inquiries Act since the Second World War, the Grushenko hearings. And we later found out that the RCMP was freaking out about this, and they created a file under Criminal Acts by Terrorists to monitor and surveil us. They had reportage going through Alberta, through banking organizations, through all kinds of international organizations to follow this group of 40 people as we made our way to Ottawa, demanding that we open up this process. So it's an example again of how when you actually get out there and you speak the truth, that can be an incredibly powerful thing. And Rock, very early when you spoke about how the ICLMG got started, you said it wasn't just about policy, it was about seeing the human face of those policies. And that's where I think the ICLMG has done such a brilliant, brilliant thing. I just want to close by saluting the work of ICLMG, because ICLMG does not play games. You do not, or we do not, divide and rule. There's a lot of folks who are involved in NGOs who get scared. They worry about their tax status. They worry about their donor base. They play good Muslim, bad Muslim. But the refusal to be afraid has always marked ICLMG. And I want to really salute that, because when we're not afraid, as we've learned from the civil rights movement and so many other movements, we move ahead. And that's a real tribute both to Rock and to Zan and to Tim and the steering committee and everyone who's been a part of this process. I just, one small anecdote and then I'll close. Tim, I'm sorry, I think I'm over. Earlier this year, I had a meeting with Tim, Zan, and someone who had been so slandered and so hurt by libels about terrorism and being a terrorist and whatnot. And after we met with Tim and Zan, they never batted an eyelash during this meeting. And the person that I brought to meet them kind of looked at me and they said, they didn't treat me like everyone else treats me. They listened and they asked questions and they asked what they could do to help. That's the ICLMG. And I think we can all learn a lot from that. So thank you, everybody.
Thanks so much, Matthew. That really means a lot, especially coming from you as somebody who's been so dedicated and passionate and constant in and principled in fighting against these laws and the Islamophobia and racism and discrimination that comes along with it. So thank you very much for those words and for joining us tonight and for again fitting so much into such little time. We've seen that there are a couple questions, but we are going to save them till the end, just so that we can get through the next few speakers before it's too late. But we will, we do see them, and we see a couple hands going up, but we will wait until the end just to make things a little bit easier, and so we can move along to our next speaker, who will be Roger Clark, and I'll invite him forward. I think Sam will add him. Yeah, hi, Roger. So Roger Clark served as Secretary General of Amnesty International Canada from 1988 to 1999. He led many human rights research missions to such countries as Cambodia, Rwanda, Ethiopia, Liberia, Guatemala, Nepal, and Algeria, and has served on a number of international committees and boards. Before joining the staff of Amnesty International, Roger taught French language and literature at McMaster University, the University of Saskatchewan, and Memorial University of Newfoundland. He published scholarly articles on utopian thought in French 18th century literature. In May 2001, Roger was named as a member of the Order of Canada. The citation at the time of his award read, as a volunteer and later as Secretary General of the Canadian section of Amnesty International, he devoted himself to protecting and furthering the full range of fundamental rights and freedoms of people throughout the world. In May 2002, he was awarded an honorary doctorate of letters at St. Thomas University for his dedication, commitment, and long-standing service with Amnesty International. Thanks for joining us tonight, Roger, and I'll pass it over to you.
Okay, well, I'd like to first add my thanks to ICLMG for all the outstanding work that you've done over so many years. Tim and Zan, you continually earn our collective gratitude for building and growing this essential space where collaboration, partnerships, and courage in the defense of human rights can thrive and become more effective. Although we tend to see the war on terror largely as a 21st century phenomenon inextricably linked to 9/11 and the consequent war in Afghanistan, I want to think of it for a moment in the light of events of some 20 years earlier. In doing this, I want to argue that Hassan Diab became a convenient target and a timely personification of the terrorist threat, particularly as defined by the West. This political characterization has resulted in the outrageous miscarriage of justice of which Hassan Diab remains the victim today. France has decided that he will undergo a trial driven by political convenience next April. But going back to the 4th of August, 1978, the European Convention on the Suppression of Terrorism entered into force. Essentially, the member countries of the Council of Europe aimed to reinforce cooperation both internally through national prevention policies and internationally, and I want to emphasize this piece of the quote, by modifying existing extradition and mutual assistance arrangements. End of quote. Specifically, member countries declared themselves aware of the growing concern caused by the increase in acts of terrorism, wishing to take effective measures to ensure that the perpetrators of such acts do not escape prosecution and punishment, and again, emphasis here, quote, convinced that extradition is a particularly effective measure for achieving this result. Unsurprisingly then, Canada was already actively bringing its old and outdated extradition legislation into line with that of its European allies. The resulting Extradition Act came into force in June of 1999. Its flaws and failings are now obvious to all, largely as a result of the experience of those who have been caught up in the rubber stamping mechanisms. A bright light, if I may say so, in this judicial darkness is the decision just 6 weeks ago by the Parliamentary Standing Committee on Justice and Human Rights to, quote, undertake a comprehensive study on extradition law reform and seeking recommendations on how to overhaul the current system. To coin a phrase, if it's broke, you'd better fix it. I see it then as no coincidence that the investigation into the deadly bombing of 3rd of October 1980 outside the synagogue on Rue Copernic in Paris was suddenly reactivated. It had lain dormant for almost 20 years. Unsourced and unverified secret intelligence, perhaps obtained as a result of torture, mentioned the name Hassan Diab. 8 years went by before France requested Hassan's arrest and extradition. Now is neither the time nor place to analyze the 5-year legal struggle which ended with Hassan Diab being put on a plane to Paris on the 14th of November, 2014, almost exactly 8 years ago. He spent 38 months in the Fleury-Mérogis prison just outside Paris, most of it in solitary confinement. The 2 anti-terrorist investigating judges concluded that there was no evidence to justify bringing Hassan to trial. He was unconditionally released and returned to Canada on the 15th of January 2018. He has never been charged. He has never been tried. I'll close with a brief quote from Justice Robert Maranger's 2011 decision approving the extradition. Justice Maranger said the following, quote, the case presented by the Republic of France against Mr. Diab is a weak case. The prospect of conviction in the context of a fair trial seem unlikely. We can draw our own conclusions about reasons why France now is trying desperately to put Hassan Diab on trial, even though all the evidence that was gathered over countless years has either been dismissed, rejected, proved wrong, and there is an alibi that Hassan was not even in Paris at that time. Thank you.
Thanks so much, Roger, and thanks for joining us and for all the work that you've been doing on Hassan's case and to shine a light on the problems with the Extradition Act. And it definitely is some great news, and I think testament to the work of yourself and the Hassan Diab Support Committee and so many others that we're finally going to see a parliamentary committee examine the problems with the Extradition Act, and hopefully shortly after that we'll see some concrete changes. So thanks for joining us, and thanks for everything that you're doing. Our next speaker will be Patricia Poirier. She's a former journalist with La Presse Canadienne, Le Devoir, and the Globe and Mail. She has been involved with human rights, justice, and privacy issues as a researcher and communications consultant and employee for a number of organizations, including the iclmg, the International Federation of Red Cross and Red Crescent Societies in Moscow, Rights and Democracy, and the Quebec Human Rights Commission. She currently volunteers with the Montreal Food Security and Community Care Group. With that, I'll pass it over to you, Patricia.
Thanks, Tim. Merci. Bonsoir tout le monde. I want to bring you back to 14 years ago when the iclmg launched in June 2008 on the first anniversary of the coming into effect of the Canadian no-fly list. The iclmg, with the steering committee, launched this project on the clearinghouse to investigate border control practices that were used to screen individuals at Canadian airports and Canadian-US border crossings and their impact on the rights of travelers. As we've mentioned, the iclmg wanted to put a public face, a human face on what was happening behind the scenes. We were seeing an increase of border incidents, as well as the nature of these incidents, coinciding with the implementation of the no-fly list program and the linking in real time of Canadian and US law enforcement databases and watch lists. It was well documented that racial profiling and religious profiling were targeting Muslims and members of the Arabic communities, but now that targeting was expanding to include academics who were politically involved, peace activists, labor activists, and justice activists. So with our partners at the time, and we're still at the iclmg, the BCCLA and the Canadian Association of University Teachers, the CLC, CUPE, and La Ligue, we worked together and we wanted to have firsthand information that would inform the iclmg and all the member groups' advocacy work and bring the issue to the attention of the public at large. So over a 2-year period, I worked with ROC to file access to information requests. We met with officials. We reviewed countless reports from both sides of the border related to the number of agreements, measures, programs, databases of Canada's border service agencies, the Canadian Air Transport Security Authority, the RCMP, Transport Canada, and of course CSIS. So to gather firsthand information, we set up a website and a toll-free number to allow people to report their encounters with airlines and border officials and transport officials on both sides of the border. And but the information that we collected was kept confidential unless the participants agreed to be identified. In all, I collected over 70 stories or testimonies. So we released the 55-page report in February 2010. And in it, we reviewed the growing list of databases, watch lists to keep tabs on North American travelers, how information was collected, sifted, cross-referenced, stored, and shared with government agencies on both sides of the border, and shared also with other foreign governments. So we found, of course, that racial and religious profiling had become a fact of life in Canada at the US border and for travelers, and that Muslims bore most of the brunt of these measures. We also found that most travelers would never know why they were targeted, that there was at that time and still is a real potential for abuse and violation of the travelers' rights due to the discretionary and very arbitrary powers that were granted to CBSA officials. And there was no credible redress mechanism for passengers who were repeatedly questioned, detained, sent to secondary screening at the airport, or for individuals who were randomly stopped or turned back at the border. Many, especially Muslims, told us that they no longer traveled outside Canada for fear of being targeted. And several mentioned in their testimony that Mar of Arar's ordeal was often on their minds. So at the end of this report, we recommended a number of actions to the government and members of parliament who had virtually ignored the issue. And we recommended and we wanted the government to acknowledge that racial and religious profiling was a determining factor in the way individuals were treated and caught by the no-fly list and other watch lists. And we of course maintained that this was an unconstitutional practice that violated the Canadian Charter of Rights. We also found that the no-fly list program, which was at that point when we released the report, was due to be expanded under the US Secure Flight Program, should be reviewed by Parliament in light of the Charter, because again, there was no due process or judicial review. And also we recommended an independent watchdog should be set up to monitor the border services agencies in light of the discretionary and arbitrary powers and the lack of any accountability mechanism as recommended by Justice O'Connor in his report. To this day, there is no real oversight mechanism related to the agency's national security operations. Finally, our report rightly predicted that the situation would be made worse by the North American Security Perimeter Agreement, which was released in December 2009, which for many purposes would establish one harmonized border protection and national security regime for all of Canada and the US. So I'm sure there'll be questions later. Thank you.
Thank you very much, Patricia. And it was really a groundbreaking piece of research that you worked on, and I think we'll get the link to the to that up on in the chat at some point too, because it really is still very relevant today. The testimonies and the research around the impact that watch lists have had at the border just has continued to grow. And want to thank you for all the work that you put in on that and for joining us tonight. Thank you.
Thanks.
So we'll move on to our next speaker. And we'll be hearing from Khalid El-Ghazar. Khalid has been practicing law in Ottawa for over a decade. He is recognized as a staunch advocate for the human rights of peoples affected by the national security apparatus, including rendition and torture survivor Abu Sufyan Abdulrazik, as well as adults and children put on the no-fly list. Khalid worked with one of Ottawa's preeminent local law firms before eventually beginning his own practice. In conjunction with his work as a lawyer, Khalid remains active in the volunteer community at both the local and national levels. He currently sits on the board of directors of the National Council of Canadian Muslims, a national nonprofit organization that advocates for the promotion and protection of human rights, and which is a member of the iclmg coalition. With that, I'll pass it over to Khalid. Thanks for being here.
Hey everyone, thank you, Tim. That's very kind. So I've been asked to talk about no-fly lists, and I think thank you, Patricia, for your comments. And I'll get to just how crucially important that work was in a minute. I grew up in a rural setting in rural Ontario, didn't blue collar family, didn't get out, didn't travel much. So the first time I encountered the concept of no-fly lists was actually when I was in law school. I hadn't heard of them prior to that. And there are actually two issues that I heard about in law school that really floored me as being extremely offensive. One was no-fly lists, and the other were security certificates, which Matthew very aptly touched on earlier. And I found them so offensive in the sense that, in essence, what they do is they flip the presumption of innocence on their head. You are deemed to be guilty or responsible or a threat to civil aviation or the national security of the country, and then you've got to fight your way out of this. But to add to the Kafkaesque nature of this, you're not actually going to be granted access to the evidence that you need to defend yourself. There's no robust process for the most part, and you don't have the ammunition you need to actually challenge. So, as a kind of naive law student, that really struck me as an issue, as a problem that was something that I wanted to work on. So I was very blessed in my career to have had the opportunity to do some work on this. I'll touch on some of the no-fly list stuff for the purposes of today's chat. One of the first cases I got of a no-fly list issue was a gentleman on the East Coast who was trying to fly Halifax to Toronto, so a domestic flight. Showed up at the airport on time, had met all the requirements. This is, he didn't even attempt to check in online. It was kind of a new thing at the time. And he was essentially pulled aside at the Air Canada counter and told he had to wait. They had to make some phone calls. Half an hour later, he was told he wasn't going to be allowed to board. Why? They said, because you're on some kind of list. We can't really, elaborate, but he knew there was an issue. Interestingly, he walked over to the WestJet counter and booked a ticket and flew out like an hour later. And so we knew there's obviously some problems with consistency. And anyways, because there's no robust mechanism in place, we, the council that were working on these kinds of cases, had to find sort of creative ways at getting at the no-fly list. So I remember earlier on in my career, our go-to was essentially human rights complaints. Human rights complaints, and then eventually privacy complaints under the Aeronautics Act and PIPEDA. But for the human rights complaints, the difficulty is that we didn't really have a lot of evidence that we could go on. There was nothing concrete. Obviously, the lists are classified. All of the goings on behind the scene with the intelligence community, all of that is classified. We don't have access to what the particular threat is. And that brings me to the comments Patricia made earlier about the Clearinghouse report. In every single case that I brought to the Canadian Human Rights Commission on issues of no-fly list, the main evidence that I put forward was that very report, because it had some anecdotal evidence of discrimination, in particular discrimination that disproportionately affected Arab and Muslim people when it came to no-fly lists. So it was invaluable. We had nothing else. We had very little. And in most cases, the cases settled at mediation, often because the litigants just didn't have the emotional capital. Financial was one thing, but actually wasn't the biggest issue. Many lawyers, including myself, were willing to do these pro bono. It was that there just wasn't the emotional capital to continue. A lot of these folks had been traumatized by their experiences of being othered and being singled out, in particular in public, sometimes in front of their families, colleagues, and so they just wanted to put the chapters behind them. Let me fast forward to New Year's Eve 2015. I was trying to leave the office, and I got a phone call from a friend of a friend who was trying to travel from Toronto to Boston in order for him and his son to attend the Winter Classic. It was a game between, I think, the Habs and the Bruins near Boston. And he was able to, he got his boarding pass, but his son was flagged. His 4 or 5 years old at the time, son was flagged. And so the Air Canada agent said, look, just sit tight. I've got to go make a phone call. And so he had the presence of mind to flip the monitor over and took a photograph with his cell phone of what the agent was looking at. Because you usually can't see it because of the privacy screening. So he turned it and he took a photo. And it basically had his son's name and age. And then it had the acronym DHP, deemed high profile. And so he had the presence of mind to tweet this out. He tagged Air Canada and he said in his tweet, Air Canada, can you please explain to me why my 4 or 5 year old son, whatever age he was, is deemed high profile? And that started this movement. Other, families, parents got together and started. So this kind of movement kind of coalesced online through social media. And over a matter of, I would say, a week or two, there were probably a good 15 families who had come together who wanted to basically take this issue on. They organized under the name No Fly List Kids. I became their counsel, and we basically started to push ahead with trying to, this was a kind of a golden opportunity. The human rights avenue wasn't really working that well. Privacy wasn't working that well, but now we had children. And so this was, you know what I mean? It's kind of a golden ticket. Who's going to say no to kids? And so we basically approached both the airlines and the government and said, okay, who's responsible for this? We kind of pitted them against one another and said, as you would expect, the government pointed to the airlines and said, there's absolutely no need to screen young children. So it's the airlines that are doing this unnecessarily. And the airlines are pointing to the government saying, no, we're following regulations. It's the government that needs to change. And the beautiful thing about that is there was a public acknowledgement from all sides that there was a problem, and there was a problem that needed to be fixed. And so after some we did hang the possibility of litigation there, but we really tried to avoid it as much as we could. We pushed more for more public pressure. So essentially what we did is we approached MPs from across the political spectrum. Again, who's going to oppose the notion that kids shouldn't get screened at the airport for security reasons? So we had, I think the majority of the House of Commons had sent us letters essentially endorsing the idea that there needed to be a fix. And then eventually that led to the government implementing a redress system similar to DHS TRIP in the United States. Now, is that a solution? It's a Band-Aid. It sort of gets us a little closer to where we want to be. It alleviates a headache, but ultimately the listing regime itself, the idea of listing people in the manner in which the no-fly list does it, is the problem. And I think that's the next step. And I'll end with this, is that in all of my work, whether it be all of the big wins that we've had, so the redress, the establishment of the redress system, Abdul Razik, the common thread throughout is that we wouldn't have been able to achieve those results without the activism of folks like the ICLMG, members of the ICLMG, and Canadians from coast to coast who put themselves on the line, who put their own the time and their resources on the line to assist us. I know the People's Commission, for example, and Abdul Razik, No-Fly List Kids, a bunch of parents basically got together and did this. And so we're definitely going to need continued support going forward. I'll end it on that. Kudos to Tim, Zan, and the entire team, past and present, at the ICLMG. Congrats on 20 years and looking forward to continuing to work with you. Phenomenal work so far. Thank you.
Thanks so much, Khaled. Thanks for being here tonight and joining us. And thanks for sharing that about the No-Fly List Kids. And it really was an incredible campaign. We were a little bit involved and gave, advice where we could, but definitely to see those families come together and the work that all of you did to really put the fire to the government's feet and to get results was very impressive. And as you said, that this isn't over. I think many people here know, but the list is still, the no-fly list remains secret and has never once been reviewed for effectiveness. Or so, as many people have said, it doesn't make sense why, you're safe enough to take a train or a bus or a boat, but you're not safe enough to fly. And yet we continue to ban people from flying, both domestically and internationally, and stranding people abroad by using this as well. So thanks a lot for joining us, Khaled, and for sharing that. I did want to give a brief update on some of the work we've been doing on CBSA accountability. One thing that we have finally seen is that there's legislation that went to second reading today, actually, to finally create an independent review body for the CBSA, so that if you file a complaint against this CBSA and border practices, it won't only be reviewed by the CBSA itself, as has been the case up until now, but will go to a joint review body that will also be overseeing and reviewing the work of the RCMP. It's not a perfect bill by far, and we're working currently with some of the folks who are on the call tonight and with other groups to examine it, to make amendments, and try to push for a better review bill and body than we see right now. One success we did have this summer, though, was the government was attempting to create new lax laws for searching cell phones and other digital devices at the border. And with a coalition of groups, we were able to convince the Senate to amend that bill to heighten the threshold and make it harder for border agents to search cell phones and laptops. It's, again, not perfect, but an improvement. It'll go to the House sometime this fall because it started in the Senate. And we're gearing up for the battle there because we have a feeling that the government will try to reverse some of those gains that we made. But at least we can start from a better place than where it was last spring. With that, that's the end of the presentations. I was going to give a quick update on a few of the current issues that we're working on, but a lot of them were touched on, and I think it's important that we get to the question period. So I think we'll do that right now. We were going to go until 9. If there's a lot of questions, maybe we'll go a little bit longer. But if you do have questions, we'd invite you to put them in the chat or raise your hands, and we'll call on you. Our preference, so that it moves a little bit more smoothly, are for questions in the chat. But if you prefer to raise your hand and would like to say something, just do so, and we'll call on you. And I think the first question we have is from when Matthew was speaking. There was a question about how there's still at least 2 individuals who are under security certificates in Canada. And Matthew, would you like to elaborate a little bit more on where that's at?
Oh, there we go. Sorry about that. Sure. There we go. We still have 2 individuals, Mohammed Harkat here in Ottawa and Mohammed Majoub, and both of them had their security certificates upheld, unfortunately. And Mohammed Harkat appealed all the way to the Supreme Court, and in a really horrible decision, and also the Supreme Court actually held a pretty unprecedented secret hearing during Harkat's appeal to the Supreme Court, in addition to a day of public hearings. The security certificate was upheld, and 8 years later, Mo is still fighting a battle to prevent his deportation to torture in Algeria, and he also has a 6-year-old application before the public safety minister to try and get landed status, which has been supported by thousands and thousands of people. Mohammed Majoub is still fighting deportation to torture in Egypt. And this is just an incredibly lengthy and drawn out process. So both of them are kind of in this ongoing limbo, and the Canadian government is sitting on these applications to prevent the deportations to torture. And so, we're continuing to do advocacy. And right now, in line with the Movember, which is largely focused on men's health, we are doing something called Movember, and Movember focuses on the health effects of arbitrary detention, secret trials, being threatened with deportation to torture, PTSD, solitary confinement, intrusive surveillance, all the things that Mo and Sophie Harkat have been exposed to, as well as the rest of the secret trial 5. So it's certainly, like I was saying earlier, they're no longer using new certificates, but Mr. Majoub has been subject to this certificate for over 25 years, and Mo is marking 20 years.
Thanks for sharing that, Matthew. And we're hoping to do more. We've Zan posted the letter writing campaign for Mo Harkat, and there will be more actions throughout November. And we're also hoping to release some more materials and actions as December 10th, the anniversary of Mo's security certificate, gets closer. We have another question here, and I'll just read it out. So Baljit asks, as many of the great speakers mentioned, Canada's national security regime has really targeted Muslim communities. Do you see any of this changing with what happened with the convoy, where our security agencies completely failed in being able to determine the threat the convoy posed to the safety of Ottawa citizens? So I'll open that up to all our speakers. Anybody who wants to say anything. I'll actually bring all the speakers into Spotlight, and then it'll be easier to jump in. There we go. Okay. Would anyone like to speak to that? Khalid, yeah. Oh, you have to unmute yourself.
All right, sorry. I was saying that I couldn't unmute. Short answer, no, I don't think it's going to change. All good. I don't think it's going to change. I mean, look at the evidence that's coming out of the current inquiry. You have, the lawyer for the convoy folks essentially just straight up saying that we were getting, very important intelligence right from law enforcement. I'll tell you what, that's certainly not going to happen if this was any other group of racialized or other minority communities. So frankly, no, I don't think it will change much. This might be sort of a blip. And don't get me wrong, I think the idea of the far right is something that is going to be of concern to security agencies. But do I think that that's actually going to relieve the pressure or the spotlight that other minority communities like the Muslim, Arab, and other communities have been under since September 11th in particular? I don't think so. I don't think we should even entertain the possibility that that's going to happen until we see concrete action, which we've never seen.
Matthew?
There we go. Just to add to that, there was a document released at the inquiry of an RCMP threat assessment of the convoy, and one of their main concerns was links to ISIS. This is how framed they are in this Islamophobic world. And all you need to do as well is to look at the annual public safety and CSIS threat assessment reports. Every single year, it starts with the biggest threat to Canada, despite all evidence to the contrary, is religiously motivated or Islamic extremism. And now they're kind of tagging on white supremacist stuff, but pretty much right at the bottom, almost as an afterthought in a checkbox, as if to say, right, we're also a feminist organization and we support LGBT rights, and we're concerned about white supremacy. But nobody ever gets that far, right? So at this point, it's just like all Muslims all the time. That's what these guys are about.
Thanks, Matthew. Anybody else? Maybe I'll just add for our part of ICLMG, one of the things that we also, on top of the concerns that Pallet and Matthew have shared, is also just the idea that we can suddenly take laws that have violated the rights of so many for so long, and suddenly that they become justified. For example, one of the things that, as we've talked about is financial surveillance and debanking and the CRA targeting these organizations and targeting Muslim organizations. And certainly, there's something to be said about if organizations are clearly funding criminal and violent activities, that needs to be addressed. But our concern was also that these new tools become legitimized, or rather old tools become legitimized. And then once the focus dies down on the convoy, then all of a sudden it gets even redoubled against Muslim and other racialized communities. And then it becomes even more difficult to criticize them afterwards because, as we saw with some organizations, that they applauded the use at the time, but then, even though they had criticized them in the past. So it's something that we're concerned about. We want, these issues to be taken more seriously, but we also don't want it to lead to the legitimization of these tools that are more often used, not against white supremacists, as been said, but against the Muslim community in Canada and other organizations, other communities. And also what we've seen is how this gets translated internationally as well. But I'll pass it over to Monia.
Well, very recently, I think last week, Jasmine Zine, she's a professor at Wilfrid Laurier University, released a report about Islamophobia, and she called it, in Canada actually, she called it the Canadian Islamophobia industry. This is a reference to a previous book written by Nathan Lean years ago called the Islamophobia industry, but based on the United States. And I think this is really I really like this terminology of using industry, because that captures, we focused here on the national security aspect, of course, and on the anti-terrorism legislation, but we didn't tackle at all the media, we didn't tackle the politician, we didn't tackle the journalists, we didn't tackle the speaker, the think tank who are paying a lot of money. So I think it will be, even if the, let's say, the national security focus will shift a little bit on from the Muslim to other groups, the industry is still going to be there, the actors are still going to be there, the dividends and the shares, all the shareholders are going to be there. So I think it is very important to call it as an industry, because it's not only a matter of surveillance or of national security. There are other stakeholders there, and this wouldn't be at all changing anytime soon.
I'm muted. Thank you very much, Monia. That's great to point out. And I'll see if we can get the link up in the chat to Jasmine Zeen's great report. I've only had a chance to read the executive summary so far, but it's really, yeah, something that if people have a chance to read is very powerful and really shows that this goes, as you said, Monia, beyond just the policies, but into a whole network of organizations and, as you said, think tanks and others that profit and build their careers off of Islamophobia. We have another question from the audience, and this time it's in regards to extradition. Jean asks, what is the probability of any potential review of the extradition law? Roger mentioned that a parliamentary committee had recommended a review. When does the government have to respond? So Roger, I'll pass over to you to explain a little bit more about what's going on with the committee study. I think we're just having some trouble with unmuting Roger.
Okay.
There we go. Sorry about that. Yeah.
Yes. Yeah. As I mentioned, the decision by the committee to conduct this study was made, I think, on the 22nd of September. But our information is that the things are moving fairly quickly, surprisingly. In fact, suspiciously, maybe. But the latest information is that they are gathering suggestions and recommendations for witnesses that will take its course. And the Hassan group and others involved in extradition reform, like Rob Curry in Halifax, Don Bain, who was Hassan's lawyer and still is, Alex Neve, all of us been working on this and been in touch with various people. I have the feeling, no, more than the feeling, I have the information that it was the NDP members of the committee that really got this on the agenda. Whether it will produce something that is solid and worthwhile, whether it's going to move things forward, I can only take some encouragement, but it's likely that this will not actually get underway before Christmas. I mean, I think they would like to, but I suspect that we may be looking at January. And after that, they indicate that they're going to hold at least 3 public sessions. So I don't know how quickly this will happen. The problem, of course, is that whatever the recommendations coming out of it, it's not clear how far that actually is going to extend in getting to the root causes that a number of people have referred to tonight, relating to extradition and similar things. If I could just add a little note, in the case of Hassan, he is on a no-fly list, and the irony of that is, first of all, he was put on a plane to France with no problem. But then when he was released, he was actually, Foreign Affairs facilitate his return through Iceland Air, because Iceland Air was the only airline that would accept him on the plane, even though he was at that point not guilty. So, you know, there's a nonsense going on, as Khalid described. And I just wonder now, it seems that being on the no-fly list is almost tantamount to being found guilty before you're charged.
Thanks for sharing that, Roger. And I had no idea Hassan was dealing with the no-fly list. And yeah, the more we hear about it, the more ludicrous it becomes. And you know, it's not the first time we heard about Iceland Air. For many people, I don't know how many people know, but there's also, because of the US no-fly list, there's an issue where about, I think it's 90% of flights out of Canada cross over US airspace. And so if an individual is on the US no-fly list, they're almost blocked from taking any flight from out of Canada to travel internationally because of the US list as well. So we're dealing not just with the Canadian no-fly list, but the US list also. Iceland Air is one of the few that, because of the route they take, don't necessarily fly over US airspace. And others have said that they have to fly from Montreal to Calgary and then Calgary out of Canada and things like that. Really, really Kafkaesque and troubling, you know, responsibilities placed on these people to be able to simply engage in something that so many others, you know, of us take for granted every day. I don't think I see any other questions. Are there any other questions from the audience? No. Are there any other final thoughts from any of the speakers that you'd like to add before we sign off for tonight? No, it's been a long night. Thank you very much, everyone, for being here tonight. Thank you to all our guests, to everyone in the audience, and to our wonderful speakers, Dominic, Roger, Khalid, Monia, Matthew, Patricia, Huck, and Yaver and Maureen, who and I feel like I'm forgetting others, but who have already had to leave. But thanks so much for being here with us tonight and for being with us for these past 20 years. We recently had a little get together where, you know, we don't necessarily want to be around for another 20 years. If we're good at what we're doing, then we won't have to be. But if we do have to be, I hope we'll be able to continue working with all of you, and because it really is, you know, the community and the solidarity and the work that we do together that keeps us going when things move so slowly. So thank you so much for being here tonight. One other note is that we are also going to be putting out a publication, and that publication is going to be bringing together the thoughts here tonight, the presentations tonight, but also many others we've worked with over the past 20 years to talk about some of the issues that we weren't able to touch on, because clearly there's more than we can even get to in 2 hours. So we're looking to put that out in early 2023. We'll let you know when it's coming, but thank you again, everyone, for being here. What else was the last thing? We'll be sharing the recording of tonight's presentation, so that'll be up on our YouTube channel, and we'll also be emailing out a link to everyone who joined us tonight, so you can keep an eye out for that and share it in your networks for those who couldn't join us. And just again, I'd encourage everyone, if you'd like to find out more about our work, if you're interested in joining the ICLMG Coalition, to visit us at iclmg.ca. Thanks again, everybody, and have a nice evening.